Just a little tidbit on attention to details. All you have to do to kick these people's ass is pay attention to what they're telling you. If you know that you really don't know much about how to apply certain things, you don't know how to go into the state's civic procedure, rules of evidence, you don't know how to do research on public law and all that, you don't know how to apply the state's constitution or other case laws and all the other little subtle intricacies. Whatever they give to you, just read it. Once you read what they give to you, 8 out of 10 times, there's a self-confession. This is allegedly a prohibitory case, meaning they're trying to say, hey, this guy cannot do this action, and this action is unlawful because he's had previous history of doing blah, blah, blah. And they introduced something called his criminal summary report as their alleged admissible evidence against him, meaning they're trying to use his criminal history against him to validate the current charges they're bringing against him. And within this thing that they call criminal, report summary, whatever the fuck they call it, they have a self-confession within it, just a very small. I had to zoom this about 120 times to see this shit. The regular view being 100%, so 20% more. So they put it in cursive and in small print. They self-confessed and told you two main things, which makes this dead. It says the information contained herein is based on resources available at this time and was done without interviewing the defendant, meaning without the consent of disclosure. 2, it may not identify all convictions or issues of blah, 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 blah. And by the way, probation and these are just other private contracts with other volunteer third parties. And then it goes say, this is the most important part. This summary cannot be viewed as accurate, thorough, or complete investigation of the defendant's prior record. This is a situation whereby they're trying to say, hey, we're using this record to stop him from doing this thing, or we're using this record that we're presenting to validate these current charges. But right in the fine print disclosure, they tell you this thing that we're bringing to validate our charges cannot be viewed as accurate, thorough, or complete. In other words, they are self-confessing, saying this shit is not, that this is not admissible as any evidence. There it is right there. It's inadmissible. Doesn't have any probative value, and according to your state constitution, if it's inaccurate, if it's not thorough or complete, then you're not being afforded due process. How can they be certain that this thing is true or accurate? And even worse, it's not certified, it's not signed, and when it was signed by a state attorney. Number one, that dude is an officer of the court, and the acting judge is also an officer of the court. That's conflict of interest right there. The parties within this said alleged criminal history summary report, they were also the ones creating the complaints, and they were the ones who made the arrests, and they were the ones who made the police report as witnesses. Therein lies another conflict of interest. So even if this thing was thorough, accurate, and complete, those factors still stay in place. So due process is being violated in every way. So all you have to do is just read the things they give to you, and they will always self-confess. And the reason why they do this is because when you try to appeal, or when you try to bring some alleged civil rights claim, which a lot of people love, which is good, or other claims, whether it's intentional tort, which you have to prove negligence and their obligation, whatever claim you bring, they can always use this as an out and say, well, we told you, you failed to deny it, you failed to affirmatively defend against it, so obligation and onus and liability is not on us. And they will dismiss your case for failure to state a claim. because you did not entertain this to begin with. Or even if you try to appeal, they would just ignore your shit because they gave you everything you need right here via their self-confession. And you were supposed to attack this. You were supposed to attack the validity of what they're trying to use, your quote-unquote criminal history, which they're trying to use to validate the charges that they're bringing onto you now. So read what they give to you, and the answer will be provided directly to you. All this is quasi. All this is colorable. And they don't lie to you. They tell you. It surprises me when people merely entertain this thing being quasi, but without proof. The proof is right where they give it to you. This is a practical, functional, and admissible evidence that this shit is not real. They're telling it to you. All you have to do is take their evidence as yours. Just as you would take their witness, hold their witness as yours. A lot of people don't know that. Another thing is, when they bring witnesses against you, like these cops who acted as a arrestor, the complainant, to the witness, you can actually hold their witness as yours for direct examination, and then reserve your right for, cross-examination. And then you bring these things up. You bring impartiality, you bring the Constitution, you bring service of process, warrant, all these things. You bring it up. So if worse comes to worse, if you're locked up in jail and all that, they love giving you papers that they think you cannot read or understand or comprehend. But read whatever they give to you. There's always something you can hang them with within their own instruments. And the only thing that gives you the final power to hang them is the Constitution. If you're on a federal level, the preceding, articles like the Confederation and Association. And use the rules of evidence. Use the rules of evidence. So that's just a little tidbit that I noticed, and I just thought it's necessary to just bring, because this right here could make or break a case, especially if you're in a tight situation where you don't have much resource. The solution is right here.